ceremonial sitting of the District Court of New South Wales to mark the occasion of the presentation of Senior Counsel to the Court.
I have the honour to announce that I have been appointed Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Elizabeth Mary Eden.
Frank Anthony Veltro SC, since your admission to the bar in 1997, you have made your reputation in criminal law, serving as a Crown Prosecutor for the Director of Public Prosecutions. In 2019, you were appointed as a Deputy Senior Crown Prosecutor, and since March of this year, you have been the head of the Court of Criminal Appeal Unit.
I have the honour to announce that I've been appointed as Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Frank Anthony Veltro.
Jason Downing SC, since your admission to the bar in 2000, you have made your reputation in appellate law, personal injury, coronial inquests, and public and administrative law. You have served as a legal member and chairperson of the New South Wales Cancer Council Ethics Committee, and from 2007 as a member of the New South Wales ACT AFL Tribunal.
I have the honour to announce that I have been appointed Senior Counsel for the State of New South Wales, taking rank and precedence next after my friend Jason Downing.
Andrew Francis Vernon SC, since your admission to the bar in 2000, you have made your reputation in commercial law. Your expertise focuses on property, family, corporations law and equity.
I have the honour to announce that I have been appointed Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Andrew Francis Vernon.
Bahan Varujan Bedrosian SC, since your admission to the bar in 2000, you have made your reputation in equity, appellate and commercial law. You served on the Professional Conduct Committee for a number of years and regularly assist with the conduct of the bar practice course and other workshops for new barristers.
I have the honour to announce my appointment as Senior Counsel for the State of New South Wales, taking rank and precedence after my learned friend Bahan Bedrosian.
Kenneth Leslie Mackay SC, since your admission to the bar in 2000, you have made your reputation in criminal law, serving as a Crown Prosecutor for the Director of Public Prosecutions. In 2017, you were appointed Deputy Senior Crown Prosecutor.
I have the honour to announce that I have been appointed Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Kenneth Leslie Mackay.
Jodie Antoinette Steele SC, since your admission to the bar in 2002, you have made your reputation in commercial litigation, personal injury, employment, international and appellate law. You're also an officer in the Royal Australian Navy Reserve.
I have the honour to announce that I've been appointed Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Jodie Antoinette Steele.
Justin Hogan Doran SC, since your admission to the bar in 2003, you have made your reputation in equity, appellate, commercial and international law. You are an adjunct senior lecturer at the University of Sydney and have co-authored a chapter published in Commercial Issues in Private International Law. In 2015, you were a counsellor and the Treasurer of the New South Wales Bar Association.
I have the honour to announce that I have been appointed as Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Justin Adrian Nash.
Benjamin Frederick Cadiger SC, since your admission to the bar in 2003, you have made your reputation in equity, commercial and appellate law. Your practice focuses on insolvency, banking, acquisitions, construction, intellectual property, competition, professional liability and property litigation.
I have the honour to announce that I've been appointed as Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Benjamin Frederick Cadiger.
Madeline Avenel SC, since your admission to the bar in 2004, you have made your reputation in appellate and criminal law with a passion for criminal defence. In 2018, you became a public defender.
Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Natalie Hayden.
Andrew Charles Harding, SC, since your admission to the bar in 2003, you have made your reputation in commercial litigation, equity and appellate law. Your practice has also included professional negligence, banking, insolvency, employment, intellectual property, insurance and succession matters.
I have the honour to announce that I have been appointed Senior Counsel for the State of New South Wales, taking rank and precedence next after my learned friend Andrew Charles.
Andre Raymond Zara, SC, since your admission to the bar in 2004, you have made your reputation in appellate law, commercial litigation, insolvency and restructuring. Richard William Potter, SC, since your admission to the bar in 2005, you have made your reputation in media and defamation law. You have also maintained a broad practice in commercial litigation and equity, which includes consumer and commercial disputes. In this year of virtual courtrooms and appearances by remote means, I'm particularly delighted to be able to take your bows in person, even though COVID-safe physical distancing requires 2 ceremonies. On behalf of the judges of the District Court, I congratulate you upon your appointment as Senior Counsel. When each of you took your bows announcing your rank and precedence in the order of Senior Counsel, the short recitation by me that follows demonstrates how well deserved your appointments are. The tradition of the appointment of silk finds its origin in England over 400 years ago. However, when New South Wales was colonised in 1788, there was no general right for an accused to employ counsel. The right of appearance by counsel was not strictly granted by law until 1840. Nevertheless, well before then, a practice had developed which allowed counsel to do everything for prisoners accused of a felony except addressing the jury. The disadvantage of accused and felony trials before 1840 appears from the judgment of Mr. Justice Willis in Ex parte Nichols. Referring to the then recent Mile Creek case, where 7 were hanged, His Honour said, "Who can say what might have been the effect of an impassioned and eloquent defence by counsel on the minds of the jury?" The adoption by New South Wales in 1840 of the English Prisoners' Counsel Act allowed counsel in a felony trial to make a general speech on the evidence after the close of the prosecution case. It was not until 1861 that in felony cases the speech of defence counsel could be made when all of the evidence, including defence evidence, had been presented and the Crown had the right of reply. Following that time, there emerged in New South Wales some eloquent Queen's Counsel, one of whom was Sir James Martin QC. In the Agara Gold Escort trials at Darlinghurst in 1863, Sir Martin's final address was so powerful and clever that the trial judge, alert to the possibility that the accused might be acquitted, interrupted Sir Martin's speech and ordered the recall of a critical Crown witness. Unsurprisingly, Sir Martin QC was outraged. Sir Martin is, of course, the namesake of Martin Place. Sir Martin began his career as a journalist for The Australian. In 1845, he was admitted as a solicitor, and in 1856, he was admitted to the bar. Between 1863 and 1872, he was the Premier of New South Wales for 3 separate terms and was then Chief Justice of New South Wales from 1873 until his passing in 1886. These anecdotes of legal history have been drawn from G.J. Woods QC, A History of Criminal Law in New South Wales, the colonial period 1788 to 1900. Greg Woods, an eminent silk, was appointed a judge of this court in 1997. Upon his retirement, Judge Woods was appointed as an acting judge of this court, a position he holds today. Although the right of counsel's appearance may have been founded in the legislative reforms in 1840, in the bulk of criminal cases, the defendant could not afford a lawyer. The deficiencies of the criminal legal aid system persisted well into the 20th century. Whilst reading Judge Wood's second work, A History of the Criminal Law in New South Wales, 1901 to 1995, Volume 2, I ventured on the doc brief, which was of particular importance in providing legal aid to an accused facing trial in the Quarter Sessions, the District Court, at Darlinghurst. In 1938, the Council of New South Wales Bar Association set out to address the lack of access to legal representation by adopting a version of the doc brief system which had previously operated in England. It was first introduced, as I have said, at the Quarter Sessions Darlinghurst at the commencement of the law term on August 2, 1938. The doc brief meant that any prisoner in custody awaiting trial could brief counsel if he could pay forthwith £1, 3 shillings and sixpence in cash for the service. A guinea was for counsel and half a crown for the barrister's clerk. The prisoner, however, was permitted to see only the backs of the array of counsel who were prepared to offer their services, and from there the prisoner could select one to defend him at his trial. The New South Wales Bar Association invited members who were prepared to accept a doc brief fee to be in attendance on August the 2nd, when Judge White would preside. Counsel were informed that all prisoners in custody awaiting trial would be brought into the Darlinghurst Court on that day so they could select counsel. The Sun, an evening newspaper, reported with somewhat theatrical flourish, and I quote, "Selected haphazardly from a group of 14 young barristers, Mr. J.G. Coyle, son of Judge Coyle, today secured the first brief under the new system of doc defence. From the Quarter Sessions dock, a prisoner surveyed a phalanx of black-robed backs and picked him out at random. 'I'll have the middle man of the back row,' he said without hesitation. Mr. Coyle rose smilingly to accept the brief." Close quotes. Only 2 prisoners took advantage of the doc brief on the 2nd of August. Judge White graciously said to counsel, "The court is obliged to you for offering your services from the point of view, if not of philanthropy, then of humanity. I'm only sorry there were not enough doc briefs to go around." Unsurprisingly, the doc brief scheme proved a failure. A major problem was that many accused simply did not have the necessary fee. Some counsel considered that the doc brief cheapened the profession. Apparently, the scheme limped along until war broke out in September 1939. You may all be pleased to know that I have not arranged for remand prisoners awaiting trial this morning in the Sydney District Court to be present behind you. On behalf of all the judges of the District Court, I wish senior counsel every success in your leadership roles at the bar. Please join us now for morning tea.